Hi, everyone. I'm Dr. Irene Mavrakakis, and we are going to speak about medical freedom, its constitutional basis, informed consent, bodily autonomy, and some recent court cases. This is a combined program from the Medical Freedom Caucus of the Libertarian Party and Liberty Speaks. Medical freedom has a constitutional basis. We hold these truths to be self-evident, that all men are created equal, that they are endowed by their creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness, that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. That's from the Declaration of Independence. What does that actually mean? It means that we have some basic rights of life, liberty, property, and the pursuit of happiness, and that humans created governments for the purpose of securing these rights. Let's talk about some other amendments, the constitutional basis for medical freedom, and these court cases. So the First Amendment, we talk about this a lot. Congress shall make no law respecting an establishment of religion or prohibiting free exercise thereof, or abridging the freedom of speech or the press, or the right of the people peaceably to assemble, and to petition the government for a redress of grievances. There's a lot going on here. We talk about the fact that we don't have a state religion, that you have freedom of religion, that we have freedom of speech, freedom of the press, and the right of the people to peaceably assemble. It's very interesting during the handling of the COVID pandemic, there were some serious issues with infringement upon free speech rights. Now, on the one hand, we can talk about how social media companies or any business or organization, they have a right to have rules, to kick you off their platform, to censor you. It's a voluntary relationship. However, if the government forces or coerces or colludes with social media companies to violate the First Amendment rights of doctors, journalists, and the like, we have the potential for a First Amendment violation. Interestingly enough, there's a few court cases that are ongoing. The first case I'd like to discuss is Missouri versus Biden. This case exposed the government's attempt at a systemic tyrannical censorship, arguably the most crucial issue of our time. The plaintiffs in this case included the state of Missouri and Louisiana, doctors, and media professionals who were censored. They presented vast amounts of evidence, including emails, phone calls, in-person meetings, demonstrating that the CDC, the White House, the National Institute of Health, the Census Bureau, the Surgeon General, Health and Human Services, and the FBI ordered social media platforms and traditional media to censor those who questioned the information and narrative presented by the government during the handling of the COVID pandemic. The goal of this suit was simple, was to end the government's role in censorship and restore free speech rights of Americans. One of the assumed triggers of this censorship program was something called the Great Barrington Declaration. And that really was just a whole bunch of doctors and healthcare providers and researchers who had concerns about what was being put forth related to treatment and mandates and measures of the COVID pandemic, and were questioning whether or not the science was settled and wanted to have more of a conversation related to what we should do from a medical and scientific perspective. And we must remember, in a free country, we need to have separation of science and state. The state shouldn't be involved in healthcare decisions because the science is never settled. We know this. And we must have the ability for dissenting doctors, people that are not necessarily fit in the current narrative, to have a voice and be able to speak to the public and put forth their research and their ideas. There was a recent Supreme Court ruling on this a few weeks ago. At the time, there was an injunction by a lower court preventing the Biden administration from having any discussions or promoting censorship of these physicians and journalists. And the Supreme Court ruled that the injunction would not stand and that this case would go back down to the lower courts, which it is. And there's going to be further discovery. So this is still an ongoing case. and it'll be interesting to see what happens. The next case is Berenson versus Biden. This is also an ongoing case. He's a journalist. He's suing President Biden, White House advisors, the Pfizer CEO, Pfizer board member for orchestrating a public-private censorship program against him. There is evidence of concrete injury, specifically related to this case, where he was suspended and banned from Twitter. There's evidence of causation, redressability, and particularized harm, as well as precedent, related to the Biden case. And the concrete facts have been presented with emails and other communications. And recently, even more communications were provided to Berenson and his lawyers from Elon Musk. This case is ongoing and very important. Let's talk about the 10th Amendment. The 10th Amendment discusses that the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectfully, or the people. What does that mean? It means that if it's not specifically stated in the Constitution, the federal government has no authority. The 10th Amendment is a very important amendment, although some people say that a lot of these concepts were already declared in the Constitution. This is a very important amendment to help rein in federal government overreach. There was significant federal government overreach during the handling of the COVID pandemic. The federal government should have no power over healthcare or any other public health or safety matter. Such authority was not granted to the federal government, and so was left to the states or to the people by the 10th Amendment. Public health and safety were not intended as federal authorities, but were meant to be within the purview of states or the people. Government should not make healthcare decisions for individuals or force policies on businesses. The federal government does not have the constitutional authority to institute mandates under the guise of an emergency. In particular, the mandate by the Center for Medicaid and Medicare Services that tied payments for hospitals and other healthcare entities to whether healthcare workers received the COVID vaccine or biologic was especially egregious. Let's talk about the 14th Amendment. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Not shall any state deprive any person of life, liberty, or property without due process of the law, nor deny to any person within its jurisdiction the equal protection of the law. What does that mean? It means that states can't make laws that deprive you of life, liberty, property, and the pursuit of happiness, because the state and government exists to protect those rights, not to destroy them. All state mandates lack a constitutional basis. Governors of states do not have the constitutional authority to institute mandates under the guise of an emergency. The federal and state mandates in the COVID management regime deprived Americans of life, liberty, property, and the pursuit of happiness without due process of the law. The government became destroyer of civil liberties during the handling of the COVID pandemic, as opposed to the protector. Let's think about it. What is actually the role of government? The only just laws are those that protect life, liberty, property, and our pursuit. For the people, by the consent of the government, but governed, they work for us. We must remember these things. So, public health emergencies and civil liberties. Let's talk about this. This is really the crux of the problem. Can public health emergencies violate our constitutionally based civil liberties? And in particular, the right to medical freedom, bodily autonomy, and informed consent. What legal precedents and concepts give or do not give the government or its agents the right to force or coerce medical procedures? And let's not mistake the fact that mask mandates, PCR testing, COVID vaccines and biologics, social distancing, and lockdowns will all varying forms of medical interventions and procedures. And what is bodily autonomy and what is informed consent? It's very interesting. Where did the government get the idea that they could force or coerce vaccine mandates? Well, it started in 1905. In 1905, Jacobson versus Massachusetts, there was a time where there was mandates for a smallpox vaccine in a small town in Massachusetts. And that regulation was passed. And Jacobson fought to have this vaccine, and he lost. And his consequence was that he had to pay a $5 fine. We need to remember that at the time, culture and the courts accepted that it was okay to sterilize individuals who were deemed to be intellectually inferior, and Jim Crow laws were also acceptable at the time. It's very important to be contextual with our understandings as to what happened when this law and this ruling occurred. Since then, multiple legal cases have established that people have a right to refuse medical care, even if that care saves their life. But many people will say, what about in the interest of the common good? We must remember with Jacobson versus Massachusetts, Jacobson paid a $5 fine. There was no subsequent infringement of his civil liberties. That was it. It's about $200 today. Further legal cases and precedents have occurred since then. Patients have a right to refuse medical treatment, even if it's life-saving. Cruzen versus the Department of Health of Missouri, Washington versus Glucksberg, Dobbs versus Jackson, and the list goes on, and I have the citation for many, many, many cases that establish this. And there is also the establishment of the concept of a zone of privacy, an area or aspect of our lives for which the US Constitution provides protection from government interference. We all have a zone of privacy. But what about the common good? The argument for the common good and the application of Jacobson during the COVID pandemic has recently been litigated in court. And the Ninth Circuit ruled against the Los Angeles Unified School District vaccine mandates. The teachers who sued on the basis that the vaccine mandates were unconstitutional won the case. And the basis for them winning was on multiple concepts, but two very important concepts. One, there was a misapplication of the 1905 Jacobson versus Massachusetts case in the lower court. COVID vaccines and biologics do not prevent transmission. Two, no respiratory virus vaccine has ever been shown to prevent transmission. Therefore, the application of for the common good when the medical intervention does not protect others is not valid. But there is something even more important that was discussed in this case. The level of scrutiny that was applied in the lower court was not correct. There needed to be a strict level of scrutiny. What exactly does that mean? The level of scrutiny applied determines how a court will go about analyzing the effects of a case or a law. And it determines which party, the challenger or the government, has the burden of proof. Strict scrutiny is the highest level of scrutiny. And the Supreme Court has determined that if there is any infringement upon constitutional-based civil liberties, that strict scrutiny must be applied when analyzing the case and decisions made. So we need to really look at the fact that in this case of the LA Unified School District, that the vaccine mandate was imposed as a condition of employment. But that doesn't suffice to justify the court's application of only rational-based scrutiny, a level of lower scrutiny. And also the ruling by Judge Collins, he further discussed Lane versus Franks. The The court has cautioned time and time again that public employers may not condition employment on the relinquishment of constitutional rights. Let's summarize the findings in this case. It's such an incredibly important case for medical freedom. Judge Collins, in his concurrent opinion, and I quote, "A competent person has a constitutionally protected liberty interest in refusing unwanted medical treatment," unquote. The quote, "The court has cautioned time and again that public employers may not condition employment on the relinquishment of constitutional rights," end quote. Quote again, "The Supreme Court's case law thus clarifies that compulsory treatment for the health benefit of the persons treated, as opposed to the compulsory treatment for the health benefit of others, implicates the fundamental right to refuse medical treatment." Let's talk about the concept of private businesses and mandates a little bit further. It's commonly discussed that private property owner or a business owner has the right to make its own rules. However, this concept is not applicable as it relates to the violation of civil liberties. A business requirement that an employee have a medical procedure for employment violates civil liberties and the premise that we all have a zone of privacy. As we saw in the recent LA school district case that I just discussed, public employers may not condition employment on the relinquishment of constitutional rights. Now, let's talk about HIPAA. HIPAA doesn't apply in this situation, but nevertheless, we need to think about the concepts of the health privacy laws that exist in medicine. A person out in the world should have a reasonable expectation that an employer does not have the right to know their medical conditions or whether or not they're vaccinated or not. A proposed 20th Amendment has been put forth by another organization, and I think that a 28th Amendment is absolutely necessary to remedy these civil liberty infringements as it relates to medical freedom. There's another recent case that is even more important. TB versus Blue Cross Blue Shield of Tennessee. TB was an employee of Blue Cross Blue Shield. She submitted a religious exemption for the COVID vaccine and biologic. She submitted information on her sincerely held religious belief and requested a reasonable accommodation to her declaration of the vaccine and biologic. Her exemption was denied by the company and she was terminated from employment. She filed a lawsuit and won recently by a trial by jury. She was awarded $687,240, which included punitive damages. The court found that Blue Cross Blue Shield was unable to show that it even offered a reasonable accommodation and that any accommodation would be an undue hardship to the organization. You see, we shouldn't really have to submit religious and medical exemptions for vaccines, but that's where we are right now because of the bastardization of Jacobson versus Massachusetts and a lot of constitutional infringement. But when you do submit a religious or medical exemption, in particular a religious exemption, it is not really for the judgment of the people viewing it as to whether or not they decide your religious exemption request is appropriate or agreeable to them. It's whether or not that entity can reasonably accommodate your request. And if they're reasonably accommodating other people who have medical or religious exemptions, then they have to accommodate you as long as it's considered reasonable, which of course is something that's pretty variable and has been used against people. And this is a typical case. And I'm really glad that she won. And I hope more cases occur and more cases win, because we already discussed that we have the right to religious freedom in this country. So what is bodily autonomy? It's simply the right for a person to govern what happens to their body without the threat or use of violence, aggression, or threat of negative consequences. And case law has established that we have a right to zone of privacy. Whose responsible for harm is important as it relates to various medical procedures. And for most medical procedures and interventions, if you're harmed, you have the ability to sue the company. Just think about all the lawsuits. These are FDA approved drugs where you see on TV, if you or a loved one have been injured by et cetera, et cetera, et cetera. And these are oftentimes FDA approved drugs. And later the science found that it wasn't necessarily in the best interest of a significant amount of people. But it's interesting, as it relates to vaccines and biologics, there was a law passed, H.R. 5546. This was passed in 1986. It removed all product liability from the pharmaceutical companies that make vaccines and biologics. It was passed because the pharmaceutical companies were getting sued for adverse events from the vaccines that were being given at the time. Since 1986, the number of doses of vaccines on the schedule has more than tripled. According to a FOIA request by ICANN, there have been no safety studies on the current vaccine schedule in 30 years. This law established VAERS and the Healthcare Compensation Fund, for which $7 billion has been paid out for injuries since 1986 through federal vaccine court. And it also established that Health and Human Services were supposed to do safety studies every 2 years on the vaccine schedule and report back to Congress, which, as above, according to the FOIA, that has not happened. The PrEP Act removed all product liability for COVID vaccines and biologics and established the COVID countermeasure injury program, for which you need to report any adverse events or injuries within a year of the administration. We need to think about this. In the United States, no other product has this type of liability protection. The fear of getting sued, truth be told, is a strong driver of safety and efficacy in the United States. We must remember, where there's risk, where there's potential for harm, where we have a constitution, there must always be a choice, informed consent, and the free ability to decline without any civil liberty infringement. Informed consent is incredibly important and is considered the standard of care in medicine. And it's very concerning as to whether or not informed consent was provided during the administration of COVID vaccines and biologics by those who administered them. What is informed consent? It's the process by which a patient is given all the important information, including risks and benefits about a procedure or treatment. It necessitates full disclosure of these risks, both known and expected or perceived, with the free ability to decline without force or coercion. That's tantamount to proper informed consent. It's a competition-rich process where the patient decides if that medical procedure is right for them and whether or not that doctor who may be involved in the administration of that medical intervention is right for them. And we have codes of ethics, Nuremberg, Helsinki, and Belmont, that dictate informed consent, and in particular as it relates to experimental medical procedures. Was it appropriate and within the standard of care for physicians and other healthcare providers to administer vaccines without providing informed consent? And was it enough to just say that they were following the CDC guidance? Because we know that no medical procedure is ever 100% safe and effective. That's already known. So we must remember that patients have to have the free ability to decline. And that ability to decline can't have negative consequences related to your life, liberty, property, the pursuit of happiness. Why? Well, because our Declaration of Independence, 1st, 10th, and 14th Amendments say so. That's why. Lack of informed consent is unethical, immoral, against the standard of care. Tying any medical procedure to our civil liberties violates our constitutionally protected rights, and these rights have been codified in case law. So what should physicians do? We should first do no harm, provide informed consent, offer treatment options with the discussions of the risks and benefits. We are obligated as physicians to do our due diligence, to be informed ourselves of the risks and benefits of any medical procedure, and to have an open and honest conversation with our patient. We don't tell our patients what to do. We make recommendations. We work for them. As physicians, we need to remember we're citizens of the United States, and we have to understand that there's a constitutional basis for medical freedom, informed consent, and bodily autonomy. I think we need a 28th Amendment to the Constitution for medical freedom. There's an organization that has put forth this amendment. I might make a few changes, but it really talks about how Congress, the president, state legislators, and executives and governmental agencies can make no law or executive order that impedes the individual's right to informed consent, nor right to medical choice, nor freedom of medical choice. And it goes on to further discuss the importance of medical freedom. We must remember, as physicians, to first do no harm. We must remember to separate science and state, because the science is often not settled. We have learned that lesson time and time again over the history of modern medicine. And because the science is never really settled, we cannot have the state involved in medical decisions, neither the federal government nor the state, because in the end, we have certain unalienable rights to life, liberty, property, and the pursuit of happiness. And we have a right to bodily autonomy. And we have a right to choose what we want to put in our bodies. And we should not have infringement of our civil liberties if we choose to not put something in our body and to not take any particular medical procedure. Let's work to get a medical freedom constitutional amendment put forth. Thank you so much for your time. Have a blessed day.